Welcome back to Counting to Five, a podcast about the United States Supreme Court. I'm Mike, your host, and this is our weekly YouTube live stream being broadcast live Thursday, May 3rd, 2018 at 9 p.m. Eastern Time. This live stream will also be posted as an episode of the Counting to Five audio podcast. If you're watching live, please feel free to ask questions in the YouTube live chat at any time, and I'll try to monitor it periodically and answer questions as they come up. In these weekly live streams, we try to keep up to date with the latest Supreme Court news and try and cover everything important that's happened in the court in the last week. And here's what I plan to cover today. Now, this has been a quiet week. If you've been following the court, you probably know that the court is on a record slow pace of issuing opinions this year. With less than 9 weeks left before the court recesses for the summer, the court still has 39 opinions left to issue. And so due to that backlog, court watchers, including me, were expecting the court to issue some opinions this week, but instead we got nothing. We did get 3 new cases granted for next term, and I'll be talking about each of those in a bit, but no opinions this week. Now, what's more, the court's next scheduled sitting, the next time that we're likely to get any opinions, is not until Monday, May 14th. So that means no opinions next week either. Also, no new granted cases next week. So that'll leave the court at that point with only 7 weeks left in the term to issue those 39 outstanding opinions. So this is quite a backlog, and we have quite a few opinions, including a lot of highly anticipated opinions yet to come. So here's the plan for today's live stream. I'm going to start with a very quick news update, and then follow that with a look at the 3 new cases that the court just granted for next term. And then for the remainder of tonight's live stream, I'm going to give kind of a big picture overview of this term, look at where we are right now, a quick look at the opinions that we've already seen so far this term, and a look at the cases that we're still waiting on, what's upcoming over the next 2 months. But before I dive into that, I have a request. So I mentioned that there are no opinions or new granted cases expected next week. There are also no scheduled executions in the next week, which typically leads to last-minute stay applications. There's always a possibility of emergency orders or other unexpected news, but there's a real possibility that there's going to be basically no new Supreme Court news next week. So my request to you is, I want to know what you want to hear about. If you're watching or listening to this episode before May 10th, I want to hear from you about what I should cover in next week's live stream. It could be specific cases or legal issues you want me to talk more about, general questions about the court or the justices, whatever you want to hear about, let me know. You can email me at mike@countingto5.com or leave a comment in the show notes page at countingto5.com or on the YouTube or Facebook page. You can tweet at countingto5, or you can leave me a voicemail at 774-226-8685. That's 774-2-COUNT-5. But let me know what you want to hear about, and then I'll do my best to tackle whatever you send at me as much as I can cover in next week's episode. So with that out of the way, let's jump right in and talk about the news. I have one update, and this is related to Justice Sotomayor's shoulder injury. Now, a few weeks ago, it was on Monday, April 16th, Justice Sotomayor fell in her home, breaking her shoulder. Now, this was originally reported as a minor injury. It was said that she would just have a few weeks with her arm in a sling and some physical therapy. However, it was later determined that the injury was much more serious than initially thought. It was described, here's a quote, as a multi-part displaced head-splitting fracture of her proximal humerus. The proximal humerus refers to the ball of the ball and socket shoulder joint. And as a result of this injury, this Tuesday, that's May 1st, Justice Sotomayor had a full shoulder replacement surgery. Now, the court reported that the surgery went well. She was released on Wednesday from the hospital and is recuperating at home. She's supposed to have a sling for several weeks and several months of physical therapy, but is expected to recover full shoulder mobility. That's the word from the court about the latest on Justice Sotomayor. The court has said that this is not her injury and surgery and treatment won't interfere with any court conferences, and the court assures that it won't interfere with the court's work. However, at this busy time of year, spending a few days in the hospital and the sling and things like that certainly can't help. But hopefully the court will be able to go about its business and get these opinions out before the end of June. So that's the only brief news update. So let's move on to the new cert grants, the new cases that the court has added to its docket for next term, the term starting in October. Now, these 3 new cases bring us up to a total of 12 that the court has so far put on its calendar or its caseload for next term. These new cases will likely be argued in either the October or November oral argument sitting. We won't know for a while yet until the court starts having calendars come out. But there's 12 cases so far. And let's just talk about each of these new cases. Now, the first case is a case called Bucklew v. Precythe. Now, this is a case that we talked about in a previous live stream episode. And it involves a death row inmate named Russell Bucklew in Missouri who had been scheduled for execution on Tuesday, March 20th. Now, he had been convicted of murder and a number of other violent acts, including kidnap and rape and attempted murder and other violent assaults related in this to the murder, and he had been sentenced to death and was scheduled to be executed by lethal injection. Now, he brought a claim arguing that lethal injection, as applied to him personally because of his special circumstances, would be cruel and unusual punishment. Now, those special circumstances are that he suffers from a rare disease known as a cavernous hemangioma, which apparently involves unstable blood-filled tumors in his head, neck, and throat, including a throat tumor that obstructs his breathing. Now, these tumors apparently easily rupture and bleed, and the claim is that the breathing stress of the lethal injection will likely cause his throat tumor to burst, causing him to painfully suffocate after choking on his own blood rather than dying from the lethal injection protocol. And due to these unique medical circumstances, this would be cruel and unusual punishment as applied to him. Now, the court issued an order staying his execution pending their consideration of his petition, his cert petition for the court to take his case. That stay was by a vote of 5-4, and it broke along the stereotypical ideological lines, with Justice Kennedy joining the 4 more liberal justices in deciding to grant the stay application. And so that was a stay pending to give the court time to consider his petition. Now they have considered and have granted that petition. So they've actually granted that, and they will be hearing this case next term. Now, the legal issue here is that there's a Supreme Court case called Glossop v. Gross. And under that case, the court held that when someone wants to challenge a method of execution as cruel and unusual, the challenger has to propose an adequate alternative method of execution that would be less cruel. This is a very controversial aspect of the cruel and unusual punishment test. Some have kind of characterized it as grotesque to require the condemned inmate to propose their own method of execution. But the court will be considering some issues related to this. One is just some details about how this needs to be proved, what sort of evidence needs to be presented about alternatives, and whether something is or is not more or less cruel. And also there's this second kind of legal question that the court is being asked: does this test apply when this is an as-applied challenge? Meaning when he's not saying that lethal injection across the board is cruel and unusual, but only lethal injection as applied to him personally due to his particular circumstances. And interestingly, the Bucklew, that's the condemned inmate, he had proposed a lethal gas as an alternative to the lethal injection, which apparently is allowed under Missouri law, but hasn't been used in decades. Now, an interesting thing about this case and the grant, So when someone petitions the court to take their case, they propose what's known as the question presented, and the question presented is a very brief statement. Sometimes as short as a single sentence, sometimes a few sentences to kind of set up the context, but a very short presentation of the specific legal issue that the court is being asked to resolve. And typically and this may be one single question, or some cases may have multiple questions, multiple separate questions presented that the court is being asked to resolve. And usually the court just grants these questions presented exactly as written, just how they're presented by the petitioner. If the court decides to grant the petition, then it leaves those questions alone. But sometimes the court, if there's multiple questions presented, will only grant some of those. And occasionally the court will either rewrite a question or add additional questions that they want added to the case. Now, once the court has granted a case, the arguments from the parties are supposed to be limited to issues that are basically fairly contained within the questions presented. So those questions presented kind of establish the scope of what the court is really interested in deciding in the particular case. So with that background, in this case, the Bucklew case, the court added an additional question that it wants the parties to brief and argue, in addition to the questions that Bucklew had proposed about the how this proposal of alternative methods of execution, how that applies to him. The court added a new question, and here I'll read the new question. And it reads, whether petitioner met his burden under Glossop v. Gross to prove what procedures would be used to administer his proposed alternative method of execution, the severity and duration of pain likely to be produced, and how they compare to the state's method of execution. So it's questioning whether the petitioner has met this requirement under a previous case. Now, keep in mind, he was arguing and has argued that requirement shouldn't even apply in his circumstances, but the court has added an additional question. So what this looks like to me is that this is a question that's added by the justices who were opposed to granting this case in the first place. Presumably the four more conservative justices who opposed staying the execution in the first place, and they've added an additional question kind of challenging whether he's even met the standards to bring this challenge in the first place under their existing precedent. So it's just an interesting kind of little twist on that case. So let's move on to the next case. The next case the court granted on Monday is called Lamps Plus v. Varela. Now, this is a case about the Federal Arbitration Act, and specifically it's about class action arbitration. So let me back up a little bit. Here's the basic facts of the case. The plaintiff is a man named Frank Varela, who's an employee of a company called Lamps Plus. Now, when he was hired and started working at Lamps Plus, he signed an arbitration agreement with the company. And that arbitration agreement requires the arbitration of all claims arising out of the employment relationship. Now, if you've followed the Supreme Court for a while, you may know that these cases concerning these arbitration clauses, this is a recurring subject on the court's docket. And there's a federal statute called the Federal Arbitration Act, a very old statute, which says that the courts are required to enforce these types of arbitration agreements. These are valid and enforceable, and if someone has a valid agreement to arbitrate, then the courts are supposed to kick cases out and require the parties to go to arbitration and have claims resolved in arbitration. Now, the specific issue here is an issue the court has also dealt with multiple times, is the issue of class arbitration. Now, the one big issue with these arbitration agreements is that many plaintiffs and especially plaintiffs' attorneys who want to bring various types of actions against companies often want to bring them in the form of a class action. Class actions where you aggregate claims by a whole bunch of people who are bringing closely related legal claims and bring them in a single lawsuit, and it can make claims which standing on their own may not be worth enough money to be worth litigating. It can turn them into a larger dollar value case that's worth bringing. And so the issue is, if someone is forced into arbitration rather than litigation, then they've lost the ability to bring these class actions. Now, there are procedures where some arbitrations can be brought as class action arbitrations. And so the question here is, under this agreement that Varela signed with Lamps Plus, can he bring he has to arbitrate, so that's not disputed in this case that he has this arbitration agreement. The question is, can he bring a class action arbitration? The specific issue in that case was related to a data breach. Someone from outside the company obtained employees' W-2s, and so Varela brought a class action against Lamps Plus for claims that are related to this data breach. So privacy-related claims and things related to this data breach. Now, so the issue is, he wants to bring a class-wide arbitration, and the argument is that the arbitration agreement is doesn't say anything about class actions. It doesn't mention them one way or another. It doesn't say that class action arbitration can't be brought. It doesn't say that it can. It uses broad language about saying that all claims that could be brought in court must be brought in arbitration. And a lower court held that under state contract law, ambiguities in a contract are supposed to be interpreted against the draft. I'm sorry, my feed briefly cut out, but I'm back now. I was just saying that there's a fairly common contract law doctrine which says that if there's ambiguities in a contract, they should be interpreted against the party that drafted the contract. And lower court said that because the contract, this arbitration agreement, didn't specify whether class actions could be brought in the arbitration or not, that was ambiguous, and that it should be interpreted to allow those class actions by interpreting it against Lamps Plus, the company who drew up the arbitration agreement. Now, Lamps Plus has disagreed with this interpretation and argues that the contract only allows that substantive claims, so that the particular legal claims that could be brought in litigation but can be brought in arbitration, but not procedural devices like class actions. And they argue the whole point of arbitration is to provide a cheaper and more streamlined procedure, and that purpose is undone if litigation tools are imported into, expensive and burdensome litigation tools like class actions are imported into the arbitration context. And Lamps Plus also argues that basically the lower court was evading direct Supreme Court precedent that explicitly rejected an inference of class-wide treatment from just a bare arbitration agreement. So that's the issue the court's going to confront in that case. And now the third and final case this week of newly granted case is another class action related case, and this one is called Frank v. Gauss. And this is a case about Cypress settlements. And I'll come back to that in a second and explain what that means. But first, just some real brief class action background. So as I mentioned just a minute ago, class actions allow the aggregation of a larger number of small claims, and those individual claims may be too small to be worth suing over. But when those claims are all brought together in a class action, an entire class of people's claims can all be resolved in one single action. And the important thing here is the non-parties that are members of the class. So the people who are defined to be members of the class but haven't actually brought the lawsuit themselves, they're still bound by this. Their legal claims get resolved just as if they had brought action themselves. And they are barred from afterward bringing their own separate action on those same issues because they've already been resolved. And as a result, the class action requires certain things like notice to the class members and an opportunity for them to opt out of the class action if they don't want to be a part of it. But class actions are frequently settled because with so much money on the line, many defendants don't want to risk an enormous verdict. So many class actions reach a settlement. In class actions, unlike just a typical non-class litigation where the parties can just agree on the terms of a settlement, in a class action, settlements must be approved by the judge. The purpose of this is to protect the rights of absent class members, and to make sure that whatever settlement is reached by the parties who are present there is also fair to the non-parties, the absent parties, the members of the class who are not actually participating, but are still, their rights will be determined by this class action. And settlement agreements also will cover things like the attorney's fees and things like that. So a judge has to approve these things before they go through. Now, the doctrine called Cypre, and that's spelled Cypres, and it comes from that's kind of a anglicization of a French part of a French phrase that means as close as possible, and it comes from the law of wills and trusts. And the idea there is sometimes in a will or a trust or some sort of legal instrument like that, some purpose will be in that a will may have a trust may have some purpose it's supposed to achieve, but that may, through the passage of time, become impossible. And the Cypre doctrine says that courts are supposed to just reinterpret the contract to come as close as is possible to the original intent. So a simple example was, suppose someone had set up a trust that was supposed to provide funds to preserve some local historic landmark. But then suppose subsequently a hurricane swept through and just completely obliterated that historic landmark so that it no longer existed. Well, that trust is still there with these funds set aside that are supposed to preserve it. It now can't be preserved because it's gone. So what happens? The court may invoke this doctrine to say that that money that was supposed to go to preserve this historic landmark should be instead put toward other similar historic preservation purposes in the area, because that's as close as you can come to the original intent of the drafter. So what does this have to do with class actions? Well, in recent decades, this idea has been kind of brought over to the class action area, and the original purpose of it was to deal with funds that were paid by a defendant in a class action that were unable to be paid to actual class members. So, just as a simple example, suppose there was a product liability class action, and suppose there were, say, 100,000 units sold of whatever this supposedly defective product was, and it was determined that each purchaser of these 100,000 units was entitled to a $20 refund. Well, that would amount to $2 million, and the company might be required, the defendant, to pay that $2 million into a settlement fund. And from that fund, the attorneys would be responsible for identifying and paying as many of these purchasers of the 100,000 units as it was possible to find, and paying them each their $20 refund. But there's going to be some unclaimed funds. Some number of those people, and often a large number, will be unidentifiable. Now, traditionally, the unclaimed funds would just revert back to the defendant, so that the company paid in this $2 million. If $1 million is left over at the end because they can't identify half of the people who purchased these units, then the company gets that $1 million back. As a response to that, because that was seen as kind of a windfall to the company and not serving the proper deterrent functions that litigation is supposed to serve, this Cypre option said that the remaining funds should instead be used to go to some cause, usually it's some nonprofit or charity that is in some way related to the subject of the lawsuit. So the idea would be, in my example with the defective product, maybe it would go to some nonprofit organization that warns consumers about defective products. So that the money would be used for serving a similar related purpose instead of just reverting to the company. Now, over the years, this Cypre has become a major feature of some class actions, where instead of just being used to deal with leftover funds that can't be distributed, funds are specifically designated in class action settlements to go to some third party in the first place. And this is very controversial for reasons I'll explain in a moment. But first, let me just briefly give the brief facts of this particular case. Now, this particular class action involved here was a class action against Google. and it was the claim was it was related to in web browsers. When someone clicks on a link in a web browser, the browser sends a request to the web page that's been clicked, and some part of the information that's typically sent to that web page is the referring website. So it's the URL of the website that where the link was that the person clicked. So it's the website that's the person is coming from, and this lets websites know like where they're getting their traffic from. They can see what sites are directing people and sending people to their website. However, when these links are coming from a search engine like Google, these headers that go to the requested website, they will often include the search terms that were in the search that the person clicked the links from. So people's search terms will get transmitted to the websites that they're visiting from Google. Now, this was a class action against Google, alleging privacy violations due to these search terms being transmitted to other websites. And it was brought on behalf of an estimated 129 million US users of Google. Now, there was a settlement agreement was reached between Google and the attorneys for the plaintiffs, and the agreement called for an $8.5 million settlement fund that would be paid by Google, and that would cover the claims of all 129 million US Google users. They would all those claims would be extinguished. However, Google was not required to make any changes to its policies or practices, and no money was given to any of the plaintiff class. Those 129 million users did not receive any money, with the exception of the class representatives who got some small fee for personally participating. And so it's $8.5 million going to the settlement fund, and class counsel were going to get 25% of that settlement fund, so over $2 million going to the attorneys. And the rest of the fund was designated to go to 6 organizations for the purpose of promoting public awareness about internet privacy. And those organizations were the World Privacy Forum, Carnegie Mellon University, the Center for Information Society and Policy at Chicago Kent College of Law, the Berkman Center for Internet and Society at Harvard University, the Stanford Center for Internet and Society, and the AARP. So those 6 organizations were going to receive 75% of this $8.5 million settlement fund. So what happened is a legal challenge was brought by objectors to the settlement. So people who are members of the class, when given notice of a proposed settlement, have an opportunity to object to it. And then there were objectors to this settlement, and they argued basically that this settlement is inappropriate, and they're basically challenging the lack of legal guidelines or rules about how these type of cypre settlements are used. And they complain specifically in this case that this settlement provides nothing to the actual members of the class, although the attorneys are receiving large fees from it. And they argue that there's some conflicts of interest here. 4 of those organizations that are getting money here already receive money from Google, in some cases very large amounts of money, which suggests that to some degree this may be kind of a shell game where Google can just designate money that they would have given as a charitable contribution anyway, instead comes as a settlement, part of their litigation settlement, and in effect they end up paying nothing to the extent that the money is just being moved from one accounting line to another. And also 3 of the organizations are the alma maters of class counsel, which suggests that attorneys may be trying to benefit their own schools, perhaps for their own personal reputational reasons. And so they brought this action basically just to challenge the lack of standards and controls on this practice. Interestingly, the named objector in this case, the Frank in the name of the case, Frank v. Gauss, is a man named Ted Frank, who's the director of the Center for Class Action Fairness, which is a part of the Competitive Enterprise Institute think tank. Now, Ted Frank is well known in legal circles as a very frequent objector to class action settlements, and that's basically the the goal of the Center for Class Action Fairness that he runs is to monitor proposed class action settlements and find objectors to settlements that are regarded as either not serving the interests of the class members or to providing excessive attorney fee awards or things like that. And so he's a frequent objector in all sorts of class actions, either personally as the named objector or as the attorney who's organizing these class action settlement objectors. And so he has, with this, brought a case to the Supreme Court on one of these policy issues that he's been vocal about for quite a few years. So that brings us to the end of the cases for this week, the new cases. And so for the rest of the time tonight, I want to just kind of take a look at this term, a little bit of look back at what's happened so far in the term, and to look at some of the cases that we're still expecting to come down before the end of June. So just as a brief overview, the court's term runs every year from beginning of October to the end of June, basically. The court hears arguments in a sitting each month from October through April, and then spends the months of May and June just finishing up all its opinions before it goes on recess at the end of June. And then in July and August and most of September, the justices go their own ways. A lot of them travel, some teach classes, things like that. And then return at the end of September before the next terms beginning in October. Now, this year, the court had a total of 63 argued cases, 63 cases that it heard oral argument on. And that's basically a historic low. The court has had a dwindling docket for some time where it's been falling. Back in the 1980s, the court used to routinely hear upwards of 150 cases a term. And now they've typically been more in the ballpark of 70 cases and even in the 60s for several recent years. But this is basically a new low this year with only 63 argued cases. And one of those cases ended up being dismissed as moot. That's the United States v. Microsoft case. So that case court was not actually able to resolve the issue that they granted in that case, leaving only really 62 cases, 62 opinions total in argued cases expected by the end of the year. Now, of those 62 cases, the court has issued opinions already in 23, leaving 39 cases still expected by the end of June. So quite a few cases still coming down. And among those 39 cases that are still expected, there is a pretty substantial number, probably 8 or 9 or so cases that are very highly anticipated cases that have gotten a good amount of press. Some of them deal with kind of hot button political issues. Some are just very important for certain industries or interest groups. So there's a lot of, not just a large number of cases of opinions set to come down, but quite a few significant and highly anticipated cases. So what I'm going to do now is kind of run through this year's cases very briefly, just touch very briefly on the cases, what we've seen so far this year, just basically subject matter by subject matter. I've kind of broken these cases up into different types. Now, some of these cases could have fit into more than one category, so I've kind of just chosen where I thought they fitted for these purposes. But I think I want to run through this just kind of I think it gives a good sense of the breadth of the types of cases that the court hears in a given year. There's quite a range of different types of cases, ranging from very kind of front page type cases to some very technical things that probably of interest to no one except for litigators practicing in a particular area. But I'm going to run through really quickly the different cases the court's heard, and toward the end of it, I'll be touching more on upcoming cases, especially these high profile cases. So I'll get started. So the court had a number of cases this year that I've just kind of generally categorized as cases just related to civil litigation. There's a couple cases just about civil litigation generally. These are pretty technical cases that aren't going to get a lot of attention. The court issued an opinion in a case called Hamer v. Neighborhood Housing Services of Chicago. There's about time limits for getting extensions on filing a notice of appeal. So it's a very technical legal issue. Another case called Artis v. District of Columbia. The court issued an opinion about that. And it was about the statutes of limitations and the court had decided that statute of limitations in some circumstances, the clock basically was stopped on certain claims, state law claims that were brought in federal court. So this is another very technical litigation case. Now the next, there's a couple cases that related to lawsuits about civil rights violations. And the first of those was one that got attention not because it was particularly legally significant, but because it had very colorful facts. It was a case called District of Columbia v. Wesby. And that was a case about police had arrested a number of attendees at a kind of wild house party in a vacant, abandoned building. And the court in that case ruled that the police had qualified immunity for arresting the house party attendees, meaning that they couldn't be sued for any potential constitutional violations related to that arrest. Another case related is in the same general area was about prisoners bringing these claims, and about prisoners who bring a successful civil rights action from prison. And the court found that under the statute involved there, up to 25% of the prisoners' award if they won one of those cases had to go toward attorney's fees. Previously, some courts had held that it was discretionary and courts could choose to only require a smaller amount of the prisoner's recovery to go toward attorney's fees, but the court held that up to a full 25%, if needed to cover attorney's fees, must come out of the prisoner's award. Then there were a number of cases under different specific federal statutes. The court decided one case called National Association of Manufacturers v. Department of Defense, which is under the Clean Water Act, and it was about what court appeals need to be brought in. And the court decided they need to go to the district courts, at the federal trial courts, rather than straight to the Court of Appeals. Now, another case was called Jesner v. Arab Bank that was recently decided under a statute called the Alien Tort Statute. And the court there held that under these Alien Tort Statute claims, those are claims for violations of international law, they can't be brought against foreign corporations. Another case called Digital Realty Trust v. Summers involved the Dodd-Frank Act and specifically whistleblower protection provisions. The court found that those whistleblower protection provisions, the anti-retaliation provisions, only applied to whistleblowers who had reported the violations to the SEC, not people who had reported through other internal company procedures. In a case called Rubin v. Islamic Republic of Iran, the court dealt with the Foreign Sovereign Immunities Act and held that this was an attempt to seize cultural artifacts that were held by a museum that belonged to Iran to satisfy the victims of terrorist acts. And the court said that there needed to be some independent statutory basis for seizing the particular property that was going to be seized. They couldn't just rely on general provisions of the Foreign Sovereign Immunities Act. Another case called Hall v. Hall dealt with, this is kind of just another general litigation case, but dealt with consolidated cases when courts group multiple cases together for trial purposes, whether if one of those consolidated cases decided and others haven't been resolved yet, can someone immediately appeal? And the court said, yes, they can. And then one more case was under the Fair Labor Standards Act, which governs wage and hour claims, federal wage and hour claims. And the court held that service advisors at car dealerships are exempt from the Fair Labor Standards Act overtime requirements. So that's just a number of cases, and the court has already decided all of those cases. Those are opinions that have come down in a bunch of different civil litigation contexts. That kind of gives you a sense of the different types of cases that the court is hearing. Moving on, I'm not going to go through every case in detail, but I'll just kind of group these by topic here. The court has 3 bankruptcy cases this term, 2 of which it's already decided: U.S. Bank National Association v. Village of Lake Ridge and Merit Management Group v. FTI Consulting. And a third one that they have not yet decided, called Lamar Archer and Coffrin LLP v. Appling. That one we're still waiting on, and it's about whether false statements made by a debtor, in which circumstances are those false statements render a debt non-dischargeable in bankruptcy. The court has heard 3 patent cases this year. 2 of them One have already been decided, and those two that were decided were both related to a process called inter partes review, which is a procedure where the patent office re-examines an adversarial re-examination of a patent to kind of reconsider whether the patent was actually validly issued. And the one that was very closely watched was called Oil States Energy Services v. Greens Energy Group. Had the court that case actually challenged this inter partes review process as unconstitutional. Had the court found it was unconstitutional, it would have been a major change to patent law, but the court upheld inter partes review as constitutional, so that ended up being a less significant case. And there's a third patent case called Western Geco v. Ion Geophysical Corp. And that case is about profits. It's about the damages in a patent action and whether a plaintiff can get lost profits from extraterritorial actions. So international actions that are kind of downstream from a patent violation, are those damages recoverable? Moving on to other topics, the court heard two cases in the court's original jurisdiction. These are cases where one U.S. state directly sues another U.S. state. And these are usually concerning water rights. And there were two cases this year about water rights. One was called Texas v. New Mexico and Colorado. And that was a water dispute about the Rio Grande. And that was specifically, the court held in that case that the United States was allowed to intervene in that case to protect its own interests related to its treaty with Mexico about the river. But a second case called Florida v. Georgia hasn't been decided yet. And that's about Florida is demanding apportionment of water on a river system from Georgia, saying that Georgia is not providing enough water downstream and it's harming Florida's ecosystem. The court had two cases that I've kind of classified as just criminal law issues, just about substantive criminal law. One was called Marinello v. United States, and this was about criminal obstruction under the tax code. And the court in that case decided that criminal obstruction required knowledge of an ongoing tax investigation in order to find someone guilty of criminal obstruction. The second case is a bit different, called Lagos v. United States. It was about a statute called the Mandatory Victims Restitution Act, which requires people convicted of certain crimes to pay restitution to the victims of those crimes. And the issue there was whether the restitution required under that act included costs associated with a non-government investigation related to the crime. So that case, that's still outstanding. We haven't had an opinion yet in that case. The court had a number of cases related in one way or another to criminal procedure. It's decided a few cases. There was a case called Class v. United States, where the court held that guilty pleas don't waive someone's right to appeal on the basis that the law they were convicted under was unconstitutional. A case called Ayestas v. Davis was about the standard for the legal standard for requesting funds to pay for experts for someone who's seeking habeas corpus, so seeking to have a conviction overturned or a conviction or sentence overturned. What's the standard for requesting certain types of experts? Another case called Wilson v. Sellers was about what federal courts are supposed to do when they're reviewing a state court conviction, and some of the state courts did not explain the reasoning for their decisions. And so what is the court supposed to do with those cases? So the court already issued opinions in those cases, but there's a few more criminal procedure type cases that are still out there. One interesting one was called McCoy v. Louisiana. And this was about whether a defense attorney is allowed to concede the client's guilt over that client's objection. And the issue here was an attorney who argued that he had made a strategic decision to concede the client's guilt in order to try and avoid a death sentence in the case. Another case called Currier v. Virginia is about double jeopardy and how double jeopardy applies if someone is charged with multiple crimes and those are severed and tried in several different trials. How does that affect double jeopardy? That's still outstanding. Another case called City of Hayes, Kansas v. Vogt is a Fifth Amendment right against self-incrimination case. And that case asks whether this right against self-incrimination, whether it applies at certain preliminary hearings or only at the trial itself? So if there's preliminary criminal hearings, does that right against self-incrimination apply, and how does it apply? And then one more case was called United States v. Sanchez Gomez, and that was about challenges to pretrial physical restraints. So it was courtroom processes where people brought in for pretrial hearings were cuffed and bound in shackles, and the question there is really whether this is reviewable by the courts of appeals or not. So those are some things that are still outstanding. We're waiting for in those criminal procedure areas. There were 4 cases this term directly about criminal sentencing. 3 of those cases are about just different variations on a particular circumstance. There's a in the federal criminal system, sentences are determined by consulting something known as the federal sentencing guidelines, which provide a range of a sentencing range based on particular crimes, particular facts related to the crime, and the criminal history of the person being sentenced. But some of those ranges have periodically the Sentencing Commission, which creates those sentencing guidelines, amends those guidelines, and in some cases the recommended guidelines are lowered for certain crimes. And so a recurring problem is related to when those guidelines are lowered, whether a particular defendant is entitled to a reduction in their sentence. And the court heard 3 cases that were different variations on that, one called Coons v. United States, one called Hughes v. United States, and Chavez Meza v. United States. And then a 4th sentencing case called Rosales Mireles v. United States was more about the standard for when there's an error was made in sentencing, but the error wasn't properly objected to or appealed. At what point can someone still go back and ask a court to correct that, to fix that error? So those are sentencing cases, and there haven't been opinions in any of those yet, so those are all still outstanding. There were 2 cases that were related to appointments to federal offices. And one called Dalmazzi v. United States is a kind of an odd case, and it's about military judges and whether it's legal for a military judge to simultaneously serve on the Army or Air Force Court of Criminal Appeals and also on the Court of Military Commission Review, which reviews the appeals from military commissions like the Guantanamo detainee commissions. And it's a challenge saying that basically it's unlawful for someone to simultaneously serve in those 2 different military judge roles. Another case called Lucia v. Securities and Exchange Commission involves the SEC and their administrative law judges, or ALJs, who hear securities adjudications in the SEC. They act like judges, but they're within the agency. And the argument there is that they're not constitutionally appointed. And so the court heard arguments about that, about whether these ALJs are actually serving unconstitutionally because they haven't been appointed in the manner required by the Constitution. And those cases are also still outstanding. Dalmazzi about the military judges, and Lucia about the SEC. One case which doesn't, there's a couple cases that kind of by themselves don't really fit into a category with other cases this term. One case called Animal Science Products v. Hebei Wellcome Pharmaceutical Company deals with, it's an antitrust action involving Chinese companies. But the question there is about whether courts have to defer to foreign government representations about what foreign law requires. So it's an interesting question about the way that courts determine what the law of other countries is. The court had one antitrust case this term, Ohio v. American Express Company, and that case is asking in what's known as two-sided markets, and in particular, this case is about credit card markets, where credit card companies are both on one hand trying to get cardholders to use their cards, and on the other hand trying to get vendors to accept their cards. Whether in alleging an antitrust violation, the government has to consider both sides of that market to make their case of anti-competitive conduct. So that's a case we're waiting to hear on. One very unusual case was brought under the Constitution's contract clause. This is a case called Sveen v. Mellon, and it actually argues that a state law related to divorce which changes the beneficiary of certain insurance contracts upon divorce, whether that statute violates the contract clause of the Constitution by changing the terms of a contract retroactively. And we're waiting on a decision from the court on that. The court heard two cases related to Indian law, American Indian law. One was the Upper Skagit Indian Tribe v. Lundgren, which is about a land dispute. It's just a simple land boundary dispute. But in this case, it's complicated by the fact that one of the landowners is an Indian tribe, and there's a claim that their sovereign immunity, the immunity from lawsuits that they have by virtue of being a government, means that they can't be brought into court over this land dispute. The other case is called Washington v. United States, and this is about treaties entered into by certain Indian tribes in the Pacific Northwest, and an argument that the state of Washington, in order to comply with these treaties, needs to replace the culverts under many highways in Washington to allow the flow of salmon through those culverts. So those are still outstanding. Now let's move on. I've got a few more areas to cover, and I'm going to get to some of the most highly anticipated cases in a few of these areas. So the court heard two cases that you could call, I grouped them together as kind of separation of powers or federalism cases. These are cases about the balance between different government, either branches or different government bodies. The first of those is called Patrick v. Zinke. In this case, the court already decided, and this was about the balance of power between Congress and the federal courts, and whether Congress could amend a law to essentially require courts to dismiss a pending lawsuit. And the Supreme Court said basically Congress could in that case. The second case is a federalism case. This is Murphy v. National Collegiate Athletic Association. This was formerly called Christie v. National Collegiate Athletic Association after Chris Christie, the former governor of New Jersey, but after the change in governors, it's now Murphy. And that is a case about sports betting. This is one of the highly anticipated cases. Does a federal law bar New Jersey from repealing its prohibitions on sports betting? And that case has gotten a lot of attention, partly just because of the subject matter about sports betting and the involvement of the NCAA as the party in the case. But it's an interesting case about how far Congress can go to require state governments to be in line with federal policy, in this case in the area of gambling. The court has several cases related to the Fourth Amendment or to searches, not necessarily directly in the Fourth Amendment. One of those cases is very highly anticipated. This is a case called Carpenter v. United States, and this is a case that asks whether the government needs a warrant in order to obtain cell site location data. So this is data from cell towers that indicates what cell tower a particular cell phone was connecting to, and by using this data, the government can get a rough idea of where people are located over time. And the government has argued there that they don't need any warrant and can obtain this information there's basically no Fourth Amendment protection for this data. So that's a closely watched question that may have implications on other types of electronic data stored by third parties like cell phone providers or internet service providers or things like that. But the court had a couple other interesting Fourth Amendment search cases, both related to automobiles. There was a case called Byrd v. United States, which asked whether an unauthorized driver of a rental car has a reasonable expectation of privacy against being searched by the police. Another case called Collins v. Virginia asks whether the automobile exception, that's an exception to the Fourth Amendment protections that allows police to search vehicles without obtaining warrants first. Does that apply when a vehicle is parked in a driveway next to a house? So it's not a vehicle that's been pulled over on the side of a highway, but it's a vehicle that's parked in someone's driveway. Does that automobile exception apply? In those cases, those Fourth Amendment cases are all still pending. We haven't got opinions on that. Another search-related case is called Dada v. United States. This is not a Fourth Amendment case, but it's about a statute allowing for wiretaps, and the question there is whether if a wiretap is authorized beyond a court's geographic jurisdiction, So in violation of that statute, the statute that it provides for this, must the information that's obtained from that wiretap be suppressed in court. And that's an opinion that's being weighted on also. I mentioned earlier that the court had heard argument in a case called US v. Microsoft, but that case was dismissed as moot. That was a case that asked whether under the Stored Communications Act, the government was allowed to access email that was stored overseas, stored in a foreign country on a server in some other country. Congress passed a new statute called the Cloud Act, which explicitly allowed the government access to these data stored in foreign countries. So that ended up mooting this case when the government got a new subpoena under the new law, and took care of that. Moving on from there, we have the First Amendment. There are several First Amendment cases. I'll talk about two briefly that are I think not quite as high profile. One is called Lozman v. City of Riviera Beach, Florida. This is an interesting case that's asking whether if someone is alleging that they've been retaliated against for exercise of their First Amendment rights by being arrested, if there was probable cause to arrest them for some other reason, not for the retaliatory reason, does the fact that that probable cause exists preclude them from bringing this First Amendment retaliation claim? And this revolved around a man who was speaking at a city council meeting in Riviera Beach, Florida, and was arrested after he was making comments about corruption in local government, and brought this suit alleging retaliation. Another case is called Minnesota Voters Alliance v. Mansky, and that asks whether Minnesota's ban on political apparel at the polls, so wearing clothing or badges or pins or things with political messages, whether that violates the First Amendment's right to free speech by banning people from wearing things with political messages. Now, there are three more free speech cases. These are, I think, some of the most anticipated ones for First Amendment cases this term, and all three are in the category of compelled speech. They're all about whether the government is unconstitutionally compelling someone to speak in a situation where they don't want to be conveying a particular message. And all these are also they fit into a trend here where all three of these are cases where someone from the conservative side of the political spectrum is bringing a case under this compelled speech rationale, and alleging that the government's actions are violating the First Amendment. The first, and this is probably arguably the single most high-profile case of the entire term, is Masterpiece Cake Shop v. Colorado Civil Rights Commission, and this is a case about a Colorado baker, and whether the application of anti-discrimination laws to this cake baker, who had been asked to create a wedding cake for a same-sex wedding celebration, whether this was compelled speech to apply the anti-discrimination law to require this baker to make the cake for that ceremony. Another compelled speech case in a totally different context is Janus v. American Federation of State, County, and Municipal Employees. This is a case about union agency fees. Those are the fees that non-union members of a unionized workplace, fees that they have to pay to the union to cover collective bargaining costs and grievance procedure costs and things like that, services that the union provides for all members, not fees that go to separate political expenditures of a union, but things that go directly to the union's representational functions. Can a non-member nonetheless refuse to pay those agency fees because they require the support of positions that the person objects to, so that the union is taking positions on matters of public concern that the non-member objects to? Is this unconstitutional compelled speech? And the third compelled speech case is out of California. It's called National Institute of Family and Life Advocates v. Becerra. And this is about a California law called the Reproductive Fact Act that requires what's known as crisis pregnancy centers. And these are pro-life centers that provide pregnancy-related services, but also are intended to help to counsel women away from choosing abortion. The FACT Act, this California law, requires them to post certain disclosures related to provision of abortion that these clinics object to as compelled speech that's contrary to their messages. So that's those all of those First Amendment speeches are all still outstanding and are being highly anticipated. The court heard a couple cases this year related to tax law. One is just an extremely niche issue that is only going to be of interest to a small number of people. It's called Wisconsin Central v. United States, and this asks whether stock options are taxable under the Railroad Retirement Tax Act, which is a special kind of alternative to Social Security taxes that applies to people who work in the railroad industry. But the second case is much more has much broader implications. This is a case called South Dakota v. Wayfair, and this is a case which basically asks whether states can impose sales taxes on out-of-state online vendors, so internet sellers who have no physical presence in a particular state. Can they nevertheless be required to collect sales tax? Now, there's the court's previous precedents, which date back from the mail order catalog days, had required companies to have a physical presence in a particular state before they could be required to collect sales tax. And this is directly challenging those precedents and arguing that the court should overturn it and require and allow states to impose these sales taxes on internet companies. Moving on to another topic, there's immigration. The court had several immigration-related cases. Two the court has already decided. They were cases of Sessions v. DiMaia and Jennings v. Rodriguez. Now, both of these cases were cases that were originally heard last term when the court only had 8 justices, but in both cases, the court divided 4-4 and had these cases re-argued this case after Justice Gorsuch joined the court to be the deciding 5th member. And in one of those 2 cases, he decided with the he sided with the conservative bloc of the court. And in the other, he sided with the more stereotypically liberal bloc on the court. So these cases went opposite directions, just in terms of the political alignment. Sessions v. DiMaia was a case about a statute that allows deportation of immigrants convicted of a crime of violence. And the court found there that the crime of violence was unconstitutionally vague. It was not well enough defined to be applied in these immigration cases. The second case, called Jennings v. Rodriguez, was arguing that there was a right to a bond hearing for persons that were held in immigration detention. So these are people being held pending determination on whether they can be removed from the country, whether they're going to be deported, or if they're stopped at the border, whether they're not going to be allowed to enter the country. And some of these people can be held for extended periods of time, and the case was brought arguing that there should be a right to a bond hearing. The court there found that there was no statutory right to a bond hearing in those cases. Now, 2 more immigration cases that are still outstanding. One is called Pereira v. Sessions, and this is a pretty technical case, but it's about what procedures the government needs to follow in order to basically stop the clock. Now, immigrants, if an unauthorized immigrant has been present in the country for a certain period of time, so for at least 10 years continuously, they have a possibility to be eligible for cancellation of removal. That means that there's a procedure that may allow them to stay in the country, even if they're determined to be deportable. But there are certain, the initiation of immigration procedures stops the clock and stops an immigrant from accruing any more time that would make them to allow them to become eligible. And so the question here is what the government actually has to do in order to stop that clock. And then the other immigration case that's still outstanding, and this is the kind of the big one, is Trump v. Hawaii. This is the travel ban litigation, the Trump administration's proclamation barring entry into the country by nationals of certain countries, and it's the countries being challenged are 5 predominantly Muslim countries, and this is being challenged both in terms of whether Trump has the statutory authority to issue this ban, and also whether this ban is a constitutional violation due to claims that it's a violation of the Establishment Clause. It's basically discriminating on the basis of religion. And so that's a highly anticipated case that's still outstanding. That case was just argued last week, the last argument day of the term. Several cases this term directly relate to class actions. One case that was already decided was called Cyan Incorporated v. Beaver County Employees Retirement Fund, I'm sorry. And that case was about whether certain class actions, securities law class actions, could be heard in state courts, or if they could only be brought in federal courts. And the court there found that they could be brought in state courts. Two cases that are not yet decided. One is called China Agritech v. Resch. And this is about whether when it's a statute of limitations question about when one class action is brought and then is dismissed, and then someone wants to bring a second, just revive it and bring a new class action on the same claims, whether the statute of limitation is told, meaning is allowed to remain open, is paused so that the time remains open, so that these subsequent class actions can be brought. So that's still out there. But the other one, and this one is highly anticipated. This is one that's being closely watched. It's a case called Epic Systems v. Lewis. It's actually several cases consolidated together. And this deals with the legality of employee arbitration agreements with class action waivers. And the claim there is that these, in the employment context, these are actually unlawful. Class action waivers in arbitration agreements are unlawful under the National Labor Relations Act. And this case was argued all the way back in October, the first week of the term, and is still outstanding. So this is one that's really being watched closely. And then the final category of cases are election law related cases. One case that's got a bit of attention is called Husted v. A. Philip Randolph Institute. And that's about the legality of Ohio's process for culling the voter rolls. So states periodically remove people from the voter rolls who are believed to have moved or be deceased or no longer eligible to vote. And Ohio's process has been challenged as illegal under federal voting laws. And then there are three cases related to gerrymandering, related to the drawing of electoral districts. One case is called Abbott v. Perez out of Texas. And this is a racial gerrymandering case, arguing that certain Texas legislative districts were illegally took race into account, impermissibly took race into account in drawing district lines. And this case has an interesting issue about whether the legislature's adoption of a map that was drawn by a court as an interim election map as an interim map that was supposed to cure constitutional defects, whether the later adoption of that by the legislature kind of insulates that map from challenges to its constitutionality. That case, these racial gerrymandering cases, the court hears quite a few of them, and they tend to be very, very fact specific about the details, the demographics, and specific facts and specific legislative actions related to particular districts. So they don't necessarily always have very broad implications. The other two gerrymandering cases are the political gerrymandering cases, and these are being very closely watched. These are highly anticipated because depending what the court decides, they could create kind of a sea change in the law of creation of electoral districts. These are Gill v. Whitford, which is a case out of Wisconsin, and Benesek v. Lamone, a case out of Maryland. They're both challenges to the drawing of electoral districts along partisan lines for partisan advantage. They have opposite political valences. In the Wisconsin case, it was the Republicans who had drawn districts to favor Republicans, and in Maryland, it was the Democrats who had drawn the districts. And they also have different legal theories. The Gill v. Whitford is an equal protection challenge that argues that on the basis of tests that have been developed by social scientists, courts can use these social science tests, which go by names like the efficiency gap and partisan symmetry tests, to determine whether gerrymandering has gone too far. The Maryland case, Benesek v. Lamone, on the other hand, is quite different. That is a First Amendment challenge. It argues that drawing maps on the basis of people's partisan affiliation is to disadvantage people on the basis of partisan affiliation is First Amendment retaliation. It's retaliating against someone on the basis of protected First Amendment expression, and thus unconstitutional there. So it's two different theories, both trying to get at the same underlying problem of electoral lines being drawn on these partisan bases. And so those are being very closely watched because they could have a huge impact all across the country in how lines are drawn for electoral districts. So that's the overview. That's all of the cases for the term, the ones that have already been decided and the ones that are still outstanding, covering a number of different areas of statutory and constitutional law. And now, over the next 2 months, we'll be seeing the rest of these decisions come down, and also seeing the court gradually fill up its fall calendar for next term. They've got 12 cases already, but based on practice from the last decade or so, we can probably expect around another 20 cases or so to be added before the end of the term to fill out the fall calendar, but remains to be seen. So that's it for tonight's episode. The next live stream will be a week from today. That's Thursday, May 10th at 9 p.m. Eastern time. That's our usual weekly live stream time, Thursdays at 9 p.m. Eastern. And you can always check the Counting to 5 YouTube channel to find the next scheduled live stream. Now, as I mentioned up toward the beginning of tonight's live stream, nothing really is scheduled to happen next week at the court. And so I'm asking you a request to anyone who's watching or listening before May 10th. I want to know what you want to hear. Please contact me. Let me know what you think I should cover for next week's live stream. And again, you can email me at mike@countingto5.com, leave a comment on the show notes page at countingto5.com, leave a comment on the YouTube or the Facebook page, tweet at me at countingto5, or leave a voicemail at 774-226-8685, 774-2-COUNT-5. Let me know what you want to hear. I will cover as much as I can on next week's podcast or live stream episode. And please subscribe to the Counting 5 YouTube channel or audio podcast to make sure you don't miss future episodes. Thank you for listening. This has been Counting to 5.